Good morning, y'all. My name's Taylor Stayer. I'm with the law firm of Parker Poe in Charleston. Also with me here today are Hunter Spivey and Charles Foster with Southeastern Insurance Consultants. They're your kind of insurance gurus. They're the guys you want to listen to because I will tell you, first and foremost, insurance is critical in your business, without a doubt. As a lawyer, you'd think I'd be preaching contracts and whatnot, but insurance is a critical piece to protect yourselves. So I've done this seminar for a number of years. It's called House of Dreams. It's based on the movie Field of Dreams. Y'all remember that movie, right? And you hear that one saying, what's it say? If you build it, he will come. And they're talking about Shoeless Joe Jackson. He comes out of the cornfields, right? Same thing applies to this seminar and the same concept about building homes. If you build it, claims will come, right? Think about that. Whether it's a punch list claim, whether it's a warranty claim, whether it's a right to cure letter that you get, whether it's a formal lawsuit, it's inevitable. You will get some claim with respect to some alleged deficiency with your homes, right? What are we going to do to protect you as builders? And I will tell you, most people don't want to listen to a lawyer on Saturday morning. I get it. But I will also tell you, my job, literally all day, every day, all I do is represent home builders. That's all I do. I don't represent trades, I don't represent material suppliers. My job all day, and I've got 6 lawyers in Charleston that all we do is represent builders. So my talk today is coming from that perspective, right? That's my job. I always talk with the HBA about, hey, listen, as an industry and as an association, we've got to protect our builders. And yes, there are others, associate members, but my job is protecting home builders. So my comments come from that perspective. And honestly, right now, the reason this has been a trend for the last couple of years, this House of Dreams seminar, is because the rise in claims. It is mind-blowing to me what we're dealing with. In 2018 and 19, I thought I was incredibly busy. And that was when we were only dealing with, look at this, on average, 70 lawsuits being filed a year against builders. These are construction defect lawsuits being filed in state court against home builders. Not just, your production builders, it's your regional builders, it's your custom home builders, it's your remodelers, right? This is not just one targeted builder. I was busy with 70. And also, I'm going to tell you, this does not account for claims being filed in arbitration, which, and I will talk about this in a little bit, which is why I prefer and recommend to my clients to have those arbitration provisions, because if there's any dirty laundry, we want to keep it behind closed doors. So in 2018-19, we were dealing with 70 lawsuits a year. That's about one every 5 days. So during COVID, 2020 and 21, the number dropped. And why is that? Well, you got to think social distancing, right? We were kind of scared. We're all in our houses. People weren't having engineers come inspect their homes. You weren't having your lawyers come in. Courts were closed, so there was less access to the judicial system, so there was a decrease in claims. But you know what's happened since then? It's exploded. It is asinine to me what we're dealing with. I mean, it truly is. Look at this. In 2022, we had 126 lawsuits against builders, so that's double what we were dealing with. Last year in 2023, 176, so that's 3 times the average that we were dealing with before COVID. And this year, this is just stupid. 306 lawsuits we're on pace for. That's almost one every single day against a home builder. And these aren't just your $7,500 claims that are being filed in magistrate's court. We don't track those. I don't even consider those, legitimate claims. Those are small, ticky-tack items. These are legitimate claims that you have filed, hundreds of thousands of dollars of types of claims, millions, tens of millions if they're class action, large lawsuits against builders. I want to talk to you about my thoughts on why this is happening, right? COVID certainly had an effect on this, right? In 2020, when people are sitting at home, you had the homes that were built in 2018 and 19, right? So new construction, people are sitting at home, looking at the cracks in their drywall, the seams in their ceilings, and they're listening to those sounds, right? The exhaust fans, their HVAC units aren't blowing well. They're hearing these things and they're obsessing about it. So what do? They say, hey, builder, I want you to come fix my thing, whatever that item is. So warranty claims started rising significantly, right? Builders would go out and they would either make the repairs or not, right? They're either covered or they're not. The problem is a lot of builders didn't have the manpower, right? So these homeowners are saying, look, I've got these claims, you're either not servicing them or you're not doing it well. So they were filing claims. What about new construction from 2020 and 2021? What were we dealing with? Labor shortage? I mean, we have a whole panel across the hall talking about that right now. It's still a problem that we're dealing with today. But in 2020, people were terrified of builders. Who's going to do my work, right? But not only that, but there were material shortages. And also we had to substitute materials. So it had a negative effect on the quality of the products that we were putting out in the market. Is that across the board? No. But does it at least explain why there was a rise in claims for new construction in 2020 and 21? Absolutely. But there's something more, and there's something much bigger that I think that we're dealing with today. It's this new sense of entitlement that we're seeing from not just homeowners, but people in general. If you think about it, I've read a bunch of reports and studies on this, that during COVID, it was kind of this self-preservation. Everyone's trying to protect themselves, right? It's like me and my family. It's me, me, me. Well, now that has then transpired into something else where it's, even if they buy an entry-level product, they're expecting this luxury level, regardless of what they pay for, right? So that's the problem we're seeing, is this sense of entitlement with homeowners and plaintiffs' lawyers, to be candid, right? And unfortunately, the laws in South Carolina aren't that favorable with respect to builders. The Right to Cure Act means nothing. And we're going to talk about that. I'm working with the HBA. I'm working with some production builders on proposed legislation on how to fix that. But the problem is, right now, all the Right to Cure is a check the box. You put the builder on notice, you say, hey, I've got issues with my roof, my windows, my siding. The builder can say, hey, you know what? I'll replace your roof. I'll come out and replace all your windows. I'll replace your siding. And guess what? They can say thanks, but no thanks. You screwed it up the first time. I don't want you to come do it the second time. So they can just go file their lawsuit. That's not the same in other states. So in Georgia and Texas, I mean, there are ways that you can, in Louisiana, there are ways that you can protect builders and have some teeth to the Right to Cure. But in South Carolina, that's one of the reasons why we have such a rise in claims, because there's nothing that really prevents homeowners from moving forward with their lawsuits. Also, statute of repose, again, means absolutely nothing in South Carolina, and I'm sorry to say that. So remember, it used to be 13 years, and we reduced it to 8 years, and everyone kind of was really excited. This is all predates me, because this is 2005. This is a long time ago. I was just starting law school. But I mean, 19 years ago, that was when we had tort reform, and we reduced it from 13 to 8, and everyone's really excited about that. But the problem is that when they pass that legislation, there's an exception to the statute of repose. So you think, all right, well, after 8 years, I'm good. And you know what? If we're in North Carolina, hey, after 6 years, builders say, bye, I'm done. You cannot sue me. You cannot come after me. South Carolina is entirely different. So there's the gross negligence exception, right? What does that mean? In South Carolina, if they plead gross negligence, they can pursue claims against a builder. What do they need to prove gross negligence? Well, there's case law out there that says if you have evidence of a building code violation, that can be used to support a claim for gross negligence. Well, I've been deposing plaintiffs' experts for 15 years, and they will tell you candidly, they could walk into any home and find a building code violation. So what's that mean? Think about that. That means the statute of repose means nothing, because those experts, so to speak, can go into any home, find a building code violation, and then use that to maintain a cause of action against a builder. Again, just like with the Right to Cure, I'm working with the HBA and also with some production builders on proposed legislation on how to change that. But that's something critical. So when they talk about supporting the PAC, it's really important that we make that change on a political level so that we can push this new legislation forward. So this is my attempt at AI, okay? I went to ChatGPT and I said, hey, I want y'all to create an image for me. And I did this just yesterday. It's not too bad. But what I said was, I want you to show me architects, engineers, attorneys, homeowners, judges coming out of the cornfield, right? Just like the Field of Dreams. These are the people coming after you with claims. How do we stop them, right? How do we send them back into the cornfield, so to speak? We build a quality home. First and foremost, guys, it's on you, right? That's the number one thing we can do is build a quality home. And it starts with quality staff, making sure that you train your project superintendents, your construction managers. About 10, 12 years ago, I had a case where I represented a developer, general contractor, and during the 30V6 deposition of my client, they were going through the history and the qualifications of all of their project managers on this multifamily project. And it got to one of their superintendents, and we found out that less than 6 months before the project, they had been a chef their entire career. So you can imagine the field day that that plaintiff's lawyer had, right? At mediation and at trial, hey, Chef Boyardee built this project. Chef Boyardee, it just nonstop, right? That's the kind of problems that we ran into. And, was it fair? No. Could we counter it? Absolutely. But you don't want to put yourself in that situation. You want to make sure that you have properly trained your staff so that they know what's happening. Think about it from this way. As a general contractor, sequencing is critical, right? And we're going to talk about this with our subcontract agreements because you want to make sure your trades acknowledge that they've inspected the conditions before they begin their work so that if there are any issues that predate them, they're on the hook, right? They accept that work. That's really important, and we're going to talk about subcontract agreements in just a minute. But next is communicate well. It's kind of like that Law and Order, like everything you say can and will be used against you in the court of law. It's true, right? And more importantly, what you don't say. So if you've got these emails from homeowners or your trades asking you questions and there's nothing, doesn't look that good. I would much rather be able to defend knowing what my client has said so that we can make that position, because if you have strong contracts, I can protect you, right? But if you don't have contracts and you're not communicating, that's a really tough case to defend for a home builder. So communicate well, not only with your homeowners, but with your trades, right? And you have a call and you talk about something that's important, follow it up. As we discussed, XYZ. Is that a CYA email? Absolutely. But should you do it? Without a doubt. Because what's going to happen in a year or 5 years, or God, the statute of repose doesn't mean anything, in 10 years when you get sued, you're like, I don't remember what happened. I don't have an email. I don't have anything. Follow it up, right? You have that important call, follow it up with an email, not a text. Do not do that. That is, to me, the worst way to communicate, right? Because you've said something, you've claimed you've made a position, but you're not going to be able to recover that as easily as an email, right? As a builder, we want that preservation of records because we are going to be looking to our trades for them to be responsible for the work that they did. So communicate well, service your clients. It's kind of like my dad always says, do what you say you're going to do, right? You tell a homeowner, hey, I'm going to come out and look at these 10, 20, 30 warranty claims that you've got, these punch list items, do it, and then respond to each. Take that position, and then if you say you're going to fix it, right? It's number 2 and 3. That's the breakdown that leads to these claims. If you don't communicate well and you don't service your clients well, you're going to be dealing with a lawsuit, right? Remember this sense of entitlement? These people are saying, hey, I deserve the best. I deserve to be treated fairly. And if they don't feel like they're getting treated fairly, they're going to contact their lawyer. And then it's outside of your control. So as I mentioned at the beginning, as a lawyer, you would think I would preach contracts as your number one defense to claims. But that's not the case. I will always say to my clients first and foremost, and to anyone else who will listen, unfortunately right now it's insurance. You've got to make sure you are properly insured. You've got to know what is covered under your claims, under your policy, and what's not covered. And not just your direct insurance, and we'll talk about this, but your additional insured insurance with your trades. I'm going to harp on you a lot about your contracts, especially with your subcontractors. To me, that is the most important part, because There is no contract that I can draft for you that would prevent claims from being filed against you. If there was, every single builder in this room and in the state of South Carolina would have that same contract, right? You can't do it. So what do? In our contracts, we have provisions to protect you and to put you in the right place, the proper forum, right? That's what we can do, but we cannot say, hey, here's a contract that is going to prevent a lawsuit from being filed against you. So make sure that you have the proper insurance. On Monday, schedule a call with your broker, your agent. Go through your policy. It's that important, because I promise you there are going to be some exclusions or some endorsements that you may not know about that may prevent coverage. I mean, one example is just a roofing exclusion, right? And so I had a builder contact me and say, hey, I got a leak. And I said, send me your policy. There was a specific exclusion for roof and resulting damage related to the roof. So, well, what's that cover? So guys, know your policies. It is so critical, and I legitimately mean this. Pull out your phone, schedule time, 10 a.m. on Monday, call your broker, your agent, go through your policies. It's that important. And then after that, we're gonna talk about call your lawyer and then go through your contracts, but we'll get there. So guys, there is no one size fits all for a builder, right? The way I do it is I call my clients and say, hey, or prospective clients, tell me about your business, right? How do you brand yourself? How do you market yourself? Who are you? I want to know what kind of builder you are. How do you work with your trades? How do you work with your owners? How do you communicate and conduct your business on a day-to-day basis, right? I could give you a template contract, but I don't want to pigeonhole and shoehorn you into one type of way. I want you to tell me what's your business, and let's make your contract say that, right? That's what you should do. So call your lawyer, whoever it may be, and make sure they're a construction lawyer, right? They've got to understand the rules and the laws of construction, right? Just this year alone, there have been 5, maybe 10 different builders who have had contracts deemed to be unconscionable for various issues, whether it's an arbitration provision, which courts love to hammer, termination for convenience, that just got hammered for a builder. You see these time and time again, and if you don't have someone who understands construction law, they're not going to know that, right? So work with a construction lawyer to revise your contracts to make sure you're properly protected. So for those who don't know, picture on the left is Horry County Courthouse. I've spent years, I'm in Charleston, but I've spent years traveling up and down the coast to this courthouse. It's a great courthouse, really nice, but I don't want to be there, and you don't either, okay? When I'm in that courtroom, I'm standing and I'm talking to the judge, and yes, my back is behind you and I'm proving a point. When I turn around, there are pews lined with people, right? And nowadays, listen, there are there are news reporters who sit there and just take notes on everything that is said in open court. You'll see it in the newspaper, right? I mean, you're getting these articles daily about these lawsuits. In arbitration, guess what? Those court reporters or those news reporters aren't there, right? That's why I say, hey, if you're in arbitration, you get to keep your dirty laundry behind closed doors. So something to consider, but then the question is, how do you get there, right? So we've got court, right? This is certainly an option, and yes, I've got a number of cases where I'm involved in circuit court, at state court, and then also federal court. Question is, you gonna have a bench trial with a nice judge like this, or you gonna have a jury with your peers? But the question is, are they really your peers? Guys, this year alone, there have been 5 different verdicts that have been in excess of $16 million, right? Just against builders. I mean, these are big claims. So you gotta think about where you wanna be. Now, listen, is that to say that in arbitration you can't get popped for a big verdict? No, you absolutely can, but generally speaking, arbitrators, depending on the forum, are, I would say, more reasonable, but more importantly, those verdicts don't get published, okay? That's why you want to be in arbitrations, to, again, keep that dirty laundry behind closed doors. So at the very top, you see this unconscionable contracts. You've got to make sure you work with your lawyer if you want to have an arbitration provision to make sure that they are valid and enforceable. You've got to make sure. I promise you, guys, courts are hammering builders right now. It's not just your production builders, it's your custom home builders as well. They're getting hammered on arbitration provisions. And it's funny because there's a case out there that says South Carolina favors arbitration. No, they don't. And the judges look at that and they just laugh. And then they'll hammer you on your arbitration provision because they say it's oppressive, it's one-sided, it's not fair to these homeowners. Make sure you work with your lawyer if you want an arbitration provision to make it valid and enforceable. I always like to say it's that whole KISS thing, keep it simple, stupid, right? The more simple it is, the more straightforward it is, the more likely a court is going to enforce it.
Should we put that on the contract, in our contract with the homeowner?
Say it again.
I've been putting that in the contract with the homeowner.
What's that?
To go to arbitration.
Yes, you can, and you should, without a doubt. And so if you do it, bless you.
The cost to go to trial is astronomical.
I would agree, and it depends also on where you are in arbitration. They can be expensive as well, and we'll get into that. So, but just because you have an arbitration provision in your contract does not mean it's enforceable. Okay? So, one, if you're trying to pursue it under the South Carolina Uniform Arbitration Act, if you don't have it in bold, all caps on the very front page at the top, then it's not enforceable. That's Rule 101, right? You see it on a lot of contracts, but it's there for a reason because the courts have said you have to put your homeowners on notice of that. So that's first and foremost. If you don't have that, then you're out of luck. Unless you can get it under the Federal Arbitration Act and you've got to improve interstate commerce and it can't be a home that's already been constructed. It's got to be, where the homeowner has some involvement in the construction of the home, then the FAA would apply. But just because you have an arbitration provision does not make it enforceable. Then the question is, do you want to be in AAA or do you want private arbitration? And so AAA, as you all know, is a massive organization that runs arbitrations. Depends on your claim. You can have a single arbitrator, you can have a panel of them. But I have found consistently that the AAA does not always give you the most ideal panel of arbitrators to choose from. They may be from North Carolina. They may have no clue about South Carolina law. They may be engineers. Do you really want an engineer as your arbitrator? You've got to think, sometimes maybe, but you've got to know what your panel is, right? In private arbitration, you're allowed to then work with the other party to select an arbitrator. So this is the way I've kind of recommend to my clients is use the AAA as a shield to potentially prevent claims, because homeowners may look at that and say, hey, you know what, that's really expensive to pursue this in AAA, I'll pass. But for those that do, and they say, all right, we do want to be in AAA, you could be in AAA, and I've got a number of cases with AAA right now, and on some of them, I've got a panel that I can live with. I'm okay with it. There are others where we just got a bad draw, right? So then the question is, what do you do with that? You can then negotiate and say, hey, we will agree to private arbitration if you'll drop your breach of warranty claim, or if you will stipulate that you will not pursue punitive damages. And you can use that as a way to minimize your exposure and get into the forum where you ultimately want to be. So that's a win-win. You have the AAA as the default, but then you can use private arbitration to get where you ultimately want to be. So talking about preventing claims, this is really your first opportunity to prevent claims from arising. Formal claims, right? We all get warranty claims, that 1 year walkthrough where they'll say, hey, I've got 50 different items. Okay, well out of those 50, maybe 40 are legitimate. I always tell my builders, look, go by the black and white terms of your warranty, right? If it's covered, fix it. If it's not, say, hey, listen, we acknowledge that there's an issue, but it's not covered under your warranty. By now, it's a maintenance item, whatever it may be. then you'll find out, okay, what are we really dealing with? You know, are they going to push certain items aggressively such that they may then lead to a lawsuit? That's when you have to make the business decision of, okay, it's not covered under the warranty, but do I still make repairs? And if you do that, that's when you need to get a release for that scope of work, because it's not covered under the warranty, but you're doing it anyway. And the reason that you're doing it is because you're getting a release for that scope of work. That's one way to avoid and circumvent claims down the road. Now, I will also say, we'll talk about this in a minute, that's why it's so important to have written subcontract agreements, to where your subcontractors will either, one, perform the work because they're contractually required to, or reimburse you for any money that you then pay that owner for that scope of work, or sharing the costs, right? So it's a way to limit or minimize your exposure. Pre-suit mediation. A lot of people put these in their contracts. I'm a fan of it. I've settled several cases before we get to the actual filing of a lawsuit, right? I'm going to tell you, if it gets to the point where they file a lawsuit, it's outside of your control, right? If you've got insurance, well, fine. Then it's up to the carrier to figure out if and when they want to settle. But it's a runaway train at that time point, right? I mean, these cases, I've got a case right now that was filed in 2014. 2014, think about that, y'all. It's 10 years that builder has to deal with a claim. It's hanging over their heads. They've got to report that to their carrier each and every year. I mean, these are not claims that just get resolved like that. They're years. Single family homes, God, you would think that again, depending on where you are, if you're in arbitration, you can get that done in less than a year, right? But if you're not, you're in circuit court, God, I've got some that are 4 years old for a single family home. You don't want that weighing over your head. So pre-suit mediation, what that means is it's a provision you put in your contract that says, hey, before you file a lawsuit, you agree that we will sit down and have a formal mediation. You get your lawyer there, you get your engineers, you get your cost of repair experts, you put it together, try to resolve it. Can you? Yeah, absolutely. It can be done. So I would recommend that you do that. Again, that's another way to keep your name out of the public filings if you don't have an arbitration provision. To cure or not to cure. So this is what I was talking about earlier with the right to cure. The right to cure doesn't really have any teeth in South Carolina, but it does give you an opportunity to have what I would call free discovery. Call your lawyer, call your engineer, get out and inspect the property, document the conditions, see what they're claiming is defective, and then you do have an opportunity to try to resolve it at this stage, but they're not required to accept whatever you offer, right? But also you'll see this third point, place your trades on notice. You get a claim that says, hey, we're alleging defects with your roof, we're alleging defects with your siding or your windows. You put those trades and their carriers on notice. So as soon as I get a right to cure letter from my clients, I send a demand to the trade, demanding that they acknowledge that the homeowner is claiming their work is defective and that they honor the terms of their subcontract with my client and that they come out and inspect the conditions as well. And that to the extent there is an issue, they will defend and indemnify my client because it's their scope of work that's at issue. Same thing with their carriers. So remember, then we will send an additional insured tender because that's another policy that would then potentially apply to you as the builder. You want your subcontractors to add you as an additional insured. We're going to talk about that, but it's so critical. Remember what I said, you want as much insurance protecting you as possible, right? If you just have your CGL policy, that's okay. Would I like excess? Yes. Would I like additional insured? Absolutely. You want as much insurance to protect you as possible. This is your hard-earned money, guys, right? I mean, this is your livelihood. And if they're coming after you for these claims, you want to make sure that that money that's being paid out isn't from your pocket.
One thing.
Yes, sir.
Also, when you write through your contract, have the builder's risk policy that either you're going to write or the homeowner can get, listing each other as also insured.
Without a doubt.
If there's a claim, let the insurance company fight over it.
That's exactly right. Yep, you're spot on that. So, guys, insurance, yes, insurance. If you all walk away remembering one thing about a contract, it's this. I cannot stress this enough. I've dealt with this for far too many years. And I did some research and read some reports that they show between 20 and 30% of home builders don't have written subcontract agreements with their trades. And it's even worse in South Carolina. And I attribute that to kind of like, hey, handshake is your word, right? But you know what? Unfortunately, nowadays, remember this new renewed sense of entitlement? It also applies to our subcontractors, right? They think, hey, once these lawsuits are filed, every man for themselves. And that's the unfortunate part of it. If you don't have these written subcontract agreements with your trades, guys, you're fighting with your hands tied behind your back. You're fighting blindfolded. You will get beat, and it's not going to be pretty. You've got to have written subcontract agreements. And the reason I say that is because the homeowners, they don't have to sue your trades. They can come after just you. As the general contractor, you are ultimately responsible for your work. That's why we then have the subcontract agreements to say, hey guys, well you did the roof. If the roof is messed up, honor your work, right? That's why you have that. But the homeowner doesn't have to sue them. So let's think about this. You get sued and you get sued by the homeowner and you pursue claims against your trades, but you don't have a written subcontract agreement. What do you have? Does anybody know? Say it again? A COI? Maybe of your own. So here's the thing. If you have a certificate of insurance, right, from your trades, and you don't have a contract that requires them to add you as additional insured, you don't have additional insured from that carrier. So what you have, if you have this, right, you just have one, right, an oral agreement. Hey, I want you to come put on this. Yeah, I'll do that for 20 grand. Yeah, okay, great. And it's oral. You have no written contract, so you have a claim for equitable indemnity. You all ever heard that term before? Okay. See, I don't see too many faces that see. Yeah, so equitable indemnity is the weakest possible claim you can ever have. Remember, homeowner can sue the general contractor, the home builder, and that's it, and they can recover all of their damages. That's why you want to put it downstream. A claim for equitable indemnity that you would have against your trades could then say, all they have to do to defeat that claim is show that you are 1% responsible. And as the general contractor who's responsible for coordinating and supervising, guys, it's almost impossible to prevail on those. Yes, there are certain situations where it is either intentional or grossly negligent of whatever your trade may have done. Don't put yourself in that situation. You have to have written subcontract agreements with your trades. When you walk out, if you don't have them, call your lawyer. Say, I need something by Monday. You have to have these. It is so important. I mean,
Have also insurance in that contract?
so not only do you need to have insurance set forth in your contract for them to have certain limits, but also to add you as an additional insured. But more than that, you need contractual indemnity in those provisions. So yeah, you can have a contract and you could pursue it for breach of contract, breach of warranty, but the courts have said, hey guys, as a general contractor, really what you have is an indemnity claim. So if you don't have written subcontract in writing, right, in writing, with indemnity, you got a indemnity claim, and that's worth nothing. You don't want that. Have a written subcontract agreement with an indemnity provision. And yes, there's a whole host of other issues. Additional insured insurance. Guys, there's also the things I mentioned before. Make sure that you require your trades to acknowledge it's their responsibility to inspect the conditions before they begin their work, right? I mean, you deal with it all the time when you've got this sequencing of trades where siding applicator will come and, hey, the framer has already put up their sheathing, they then put up the weather barrier, and you know what, it's reverse lapped, right? But then they put up the siding. If you don't have a written subcontract agreement that requires that trade to acknowledge that they've inspected the conditions before, they could say, hey, that's not my responsibility, that's you as a general contractor. You're responsible for that. So you need to make sure that your trades acknowledge the conditions. So yes, that siding applicator is supposed to look to see, is that weather barrier reverse lapped? It's critical. Include those provisions in your subcontract agreement. And guys, this isn't to be mean to your trades, right? And if you're a trade in here, I don't know who everyone is, but it's ultimately to make people responsible for the work that they perform, right? Even as the general contractor, and you have find subcontract agreements with all of your trades, are you completely off the hook? Maybe, but most likely not. So it's not a matter of being cruel to your trades. It's a matter of saying, hey, I just paid you good money to do your job. And if this is ultimately shown to be defective down the road, you're supposed to be responsible for it, right? You did the work. So that's why you need these written subcontract agreements. Indemnity, we talked about provisions that you'd want in them. This is what you'd want. Making sure you've got that risk allocation. Remember, I can't write you a contract that would protect you from any lawsuit. My job is risk allocation. So I try to look at the overall exposure for my clients and I reduce it as much as I possibly can. I do that through the additional insured coverage, so we tender. I do that from my cross claims or third party claims for contractual indemnity against our trades. That's the way that you reduce your ultimate exposure. You want to keep your hard-earned money, right? This is what you need to do. Your contracts with your owners, but more importantly, your contracts with your trades for risk allocation. And yes, this anti-indemnity statute, there's a whole host of issues, but the point is, make sure that you have someone who understands construction law and how they interpret construction agreements. And this is to your point about insurance. So, and you know, guys much smarter than me, Charles and Hunter are going to talk about insurance after this, but what I do know is you need to make sure that you require your trades to add you as an additional insured, right? That's another policy that could protect you. And yeah, I mean, at the bottom, I talk about in the certificate of insurance, you said, hey, that's something, if you read it, I don't know what the exact language is, Charles will probably quote it in a minute, but it basically says, hey, this does not represent coverage, right? I don't know what the language is, but it basically says, like, this piece of paper means nothing, right? I mean, I hate to say that, but it doesn't. Right, that's exactly right, the policy rules. And so, you know, is it good to have certificates of insurance with your trades? Absolutely. I mean, then you've got their broker, you got the policies, you can then follow up and confirm. But at the end of the day, just because you have a COI doesn't mean you have coverage. Yes, sir.
And just to add to that, there's a lot of
Easily
contractors that I work with that have the subcontract agreement and just have additional insurance, waiver subrogation, but you have to list what forms you, the GC, want in that contract. Those forms, because the new policies today, they give you blanket, your policy lays out a set blanket.
Yep.
And now they've separated between ongoing and completed ops. Your trade or your exposure is a completed ops and abide by the house. So if you don't specify that form, you just say, well, your district term of policy, you meet what you're asking me for, but you don't know, you probably don't have what you're looking for. And then so you specify the forms, you want to get the COI from his insurance agent, not him.
Yep.
And that way you're putting their broker on the hook as well to make sure they're complying with the contract. It's
That's
critical.
I'm glad you brought that up. You're exactly right, because, you know, listen, remember I told you that all I do is represent home builders. Legitimately, I eat, sleep, drink, that's all I do is represent home builders. And so as part of that is we have a coverage team, right? So what they do is they're responsible for sending out the tenders, following up with the carriers, and just because you have that COI or just because you have an additional insured endorsement does not mean you're ultimately going to have coverage for that particular claim. So he is right. That's why you have to have, as I put in, the proper endorsements. So am I the guy to tell you what your endorsements are? Nope. But these insurance guys are. Your broker is. You need to talk with your broker and your agents to make sure that you have those proper endorsements to cover you. And then as I mentioned, what we've talked about is making sure that your trades agree to honor any warranties that you provide to your homeowners. Because, in a year, if you go out and there's some items that are warrantable that you're going to fix, and let's say it's $7,500. Well, you've acknowledged that it's defective and should be fixed, but if you don't have an agreement with your trades, they can say, hey, I'm not required to come back out. You've got to pay me to come do that work because we don't have a warranty with you. So be smart about it. Include this provision in your contracts as well. And I could go on for hours about contracts with your trades, but as I mentioned, at least have one in writing at the very minimum, right? So that you can maintain within an indemnity provision, so that you can maintain a claim for contractual indemnity. Guys, at the end of the day, that's our ultimate goal. Is send them back into the cornfields, right? We want to keep these claims away from us as builders, so that you all can continue to make a living, right? That's what the goal is. I'm going to now pass the baton to Charles and Hunter so they can talk about insurance, and then we can kind of roundtable any questions that y'all have got. Really, what matters is what's on your mind. So we want to be able to talk about those, but I also want to make sure you get that insurance component, because to me, that's a critical piece to your business.
All right, Alan Patterson asked a question about the builder's risk. Question of who carries it. This is part of and going to be handled in the contract with the homeowner. We strongly recommend the builder carry it. That way you know what is covered. First and foremost, your name is the first one on the check. I sound like a farmer's commercial every time we do this, talking about different scenarios. We had a builder in Anderson building a $1.8 million home. The homeowner insisted that he wanted State Farm to cover it, so that's great. I said, these are the three things we got to have. At a minimum, make sure the builders for the issues off pay. The young lady at State Farm gleefully said, not a problem. And I said, theft of building materials. She said, not a problem. I said, great, what's the limit? She said, $5,000. I said, you do understand in a $1.8 million home, the refrigerator is more than $5,000? She said, yes, sir. And I said, can we increase it? No, sir, $5,000. I was like, okay. First hiccup. And then I said, we need to ensure that profit and overhead are included. She said, I need to call you back. She came back. She said, I talked to my underwriter, and neither of us have ever heard of such, but that can be worked out with the adjuster at the time of the loss. And I told her, I said, respectfully, and I said, I'm going to give you a little advice because you sound younger than me. If you're going to stay in this industry, so the last moment that you want to find out what is and is not covered is after a loss. So these are the things we want to make certain are covered. If the homeowner insists, again, strongly encourage you to carry the builder's risk if at all possible. We start talking about the insurance for subcontractors. Looks like you're doing liability after all. As Taylor mentioned, you need to put the limits in your contract. Don't do it as an exhibit. Don't do an addendum. Have it in there. We recommend a minimum of $1 million. Depending on the size homes you build, you may need to increase that. Look at an excess policy or an umbrella policy. With insurance, you have the pearly gates and the eternal fires. The eternal fires are, can you frame? Yes. Can you fog the mirror? Great, get started. You need to give insurance prior to them starting work. You need to make certain that your name, let me see if this is the next slide. We'll come back to that. Need to be listed as additional insured. In the old days, you could have CG 2010 and CG 2037. Those sound great. I'm sure they sound like Greek to you. There have been so many changes, so many modifications. When somebody says, I'm an additional insured, it's like, great, but are you an additional insured like you lease office space to them? Or are you an additional insured where their coverage continues with yours once the product's done? Like Taylor said, the 8-year statute sounds great, gross negligence. We got a claim just recently from 18 years ago trying to allege gross negligence. So you absolutely want to be additional insured. I had a builder call me the other day. She said, hey, they did additional insured, but it didn't say including completed operations. So I said, please get me a copy of the endorsement. We'll review it. Automobile liability, at least $500,000. This is important. If you're not going to enforce a provision, don't put it in your contract. Make certain that if you put it in there, you're going to enforce it. Some of your smaller trades, this may be an issue. They may have their liability with insurance company A, and then their auto insurance is with Farm Bureau or State Farm. If that is not going to be something you're going to enforce, don't put it in there. And I'm not trying to strip down coverage, but we don't see as many claims from this as we do the general liability, obviously. The workers' compensation, there are some boxes, and we'll go over that in a few minutes, that show, one of the things, show if the owners are included or excluded. There's a box that shows that. If you work any of the borders, Aiken, Augusta, getting up to Little River, down to Hilton Head, if you've got an out-of-state contractor coming in, a subcontractor, make sure that South Carolina is listed as a covered state, because that can become an issue if you have a Georgia domiciled employee get hurt in South Carolina. They've got an option of which state they can elect coverage under, and if South Carolina is not a covered state, you could have a problem. Oh God, this one. This sounds very simple. Make sure that you're actually the additional insured. We've picked up 3 accounts in the past 12 months that their own insurance policy wasn't even in their legal name. Make certain if you're going to be an additional insured that you really are. Don't just have, Aldrich Construction. It needs to say Aldrich Builders LLC. I'll pick on Johnny and Steve because they're friends of ours. But if you're going to get the additional insured protection, you need to make sure that you are properly listed and shown. A lot of people, and it depends on what sort of staff you have, whether you're doing this or if you've got somebody in the office, many times we say, you absolutely need to be additional insured, including completed operations, and the person in the office gleefully says, we got a certificate. I'm like, certificate holder is not the same as additional insured. We have a sample certificate. Oh, that's easy. Okay, Taylor, help brother out. Where's the pointer? Yeah. There are a couple. We will send you a sample. The additional insured will either be noted here or can be written out there. We will get you a copy of the printout, but that's really not easy to read at all.
Can I ask a quick question?
Sure.
About the certificate?
Yes.
We've had situations, and I've gotten varying stories. We'll hire a subcontractor, ABC Construction Company, and that'll be their W-9. And then we'll get a certificate of insurance that's a completely different name. What are the rules? Everything has to be the exact same?
When you have a claim, they're going to come back. If you have a W-9 and you're writing check, now who are you writing the checks to? That's the first question. You write the checks to the W-9?
Yeah.
Okay. Then you're not really an additional insured at that juncture. And you're probably going to end up paying for that on audit if it's Jose Alvarez, DBA Alvarez Masonry, you can write the check to either one. But a lot of times you'll have ABC Construction say, hey, can you write it out to me instead? That's where you start running, because
They'll be riding on somebody else's insurance. That's really
you're not wrong. It happens all the time. Make sure where we talked about certificate holder and additional insured is your legal name with the Secretary of State. Whoever the W-9 is, that's who you're writing the certificate. That's who you need to make sure you're writing the check to.
We've had a ton of pushback with that, but primarily on like national companies. And the biggest one that comes to mind is the company that does my blower door test. They're out of Texas, and literally we beat that drum for like 6 months and finally got a copy of their insurance, and it was 182 pages long because they have so many DBAs they work on.
Right.
And they're like, well, we have insurance for all of our companies. Like, that's fine, but
Good.
we need something that shows the name of the W-9 we're writing a check to is insured. And we literally like page 6 was finally their company that we were writing
And
a
you
check
just
to.
brought up a great point that Taylor hears me say every time. This whole thing, we've got all our companies here. Great. If it's not in writing, it doesn't exist. And if it is in writing, you need to make sure how it's going to sound in court 3 years from now. But that's a good point. Yeah, it may be, 16 pages long, but whoever you're writing that check to, you need a certificate showing that legal entity. That's a great question. Thank you. Are there any questions on that? You want to pick it up here?
About to say, keep talking, because honestly, what we're all trying to do here, everybody has specific examples and questions that they have, because we can tell you all the things in the world with insurance, but it's a case-by-case basis. So with general liability, we talk about the sentiment towards home builders. We joke all the time they got more money than God, and at the end of the day too, that homeowner, anything that happens on that job site, in their mind, it's with you. So you get brought into a lot of claims, and I'll tell you, general liability, it's going to cover anything you could do to a third party, basically. And having the additional insureds and putting as many barriers as you can, the contracts, what an additional insured actually does, it gives you access to someone else's policy. So that means you can actually file a claim on their behalf. And I've had a builder go to a job site, he never actually got out there. It was a concrete claim, $80,000 later for something he didn't show up to. Our carrier had already started the defense, and because he had a contract and he was listed as an additional insured, he was able to get coverage. But it just goes to show you, even if you don't show up, you're gonna get brought in, because your name's on the sign and the contract's between the homeowner and you, and anything that goes wrong, they don't care who the sub was, they care it's you. And I'll tell you too, with general liability, you talk about trades and everything, if you're doing tract homes, insurance carriers will actually exclude work done in the big subdivisions, because they know they have attorneys on payroll, Lennar, all the big boys, and they get everybody who ever touched that job site involved in the suit. So that's how they do it. They basically sue everybody and try to get whatever they can. And endorsements and exclusions. So basically the way insurance works, you have one coverage form, and then what happens, they will show you, they amend the policy. So you can exclude work done by subcontractors, you can put limitations, but that's where the devil's in the details, because that amends the coverage you actually have. So with the general liability, you have coverage for bodily injury. Of course, if someone were to actually get hurt or you would cause property damage, which is the big thing. And with insurance too, the resulting damage from poor work is really where it kicks in. So if you talk about trying to do framing a window basically, and if you have water coverage come in, you want to make sure that everything's covered that would be the resulting damage. And it's not prepaid legal insurance. So one of the big benefits of insurance is whenever you actually have a carrier, they are obligated to defend you if you're named in a suit. So whether it's frivolous or not, they actually have to come to your defense and they have to come help you out. So you can either have, with the general liability, you can have it per location or on a per project aggregate. So what you want to have is, with the aggregate coverage, you're basically making sure that throughout the, or I would say,
The aggregate is going to be the most they would pay during a policy period. They have three options: per policy, per project, or per location. There's a charge, and the charge, of course, is respective of the additional coverage you're getting. You prefer per location or per project. That expands so your aggregate limit stacks.
and you want to have a blanket additional insured, which is basically giving you that same access to someone else's policy. And whenever you have that blanket, you basically have all their coverage, their limits, their endorsements, and you have the full access to their policy. And again, go into the extensions and enhancements. With subcontractors too, whenever you have that COI, what we tell you, even if you are an additional insured, you really don't know what they have. So watch out for a lot of the exclusions that your subcontractors could have, because we had a painting contractor, had a claim, they had an overspray exclusion. So basically we tried to file a claim because they were spraying the house, it hit a couple of cars, comes to find out basically they didn't have the coverage because they were spraying the paint, and too bad, so sad. So
But
just
our builder had checked every box, we were additional insured, had the contract, and still we ended up with it.
And it goes back to the builder's risk too, to where it's whenever you have a policy, you want to know what you have, because the last thing you want to do, especially with someone else's coverage, you talk to the smaller agencies and everything, if you don't specialize in home building and basically the coverage that they have, they really don't know. And we can't tell you how many home builders have coverage to where work done by subcontractors is excluded. So you got a piece of paper that basically is going to cover nothing.
Do y'all come down and review policies, subcontractor policies?
Absolutely.
Y'all just came down and inspected me, two of them came down, went through a couple. That was just for safety, right?
Who'd you have? Was it like
The
Builders
guy
Mutual
Just hired, and the girl.
with Southeastern Insurance?
I think we just handle your builder's risk. I don't think we have the liability side.
I'll do it though.
It's your replacement, you just haven't been told yet.
I guess so. I already got fired.
What you doing at lunch?
Yeah. Walking home is what I'm
He
doing.
used to work for Builder Mutual. All right.
With some of the negative enhancements, just like I was talking about, CG 2294. And basically what that does, you'll see it and they hide it, and a lot of those coverage endorsements, it looks just like a normal policy, but they're going to exclude any work done by a subcontractor. And if you're subbing everything out, in about 2018 is when Builders Insurance Group, they were one of the last big carriers, they basically started tacking it on because with the litigation in our state, it's so unfavorable, and basically they don't want to have the coverage for somebody else. And with the subcontractors, if you've got something like this, you need to make sure that the work that they're actually doing is covered. And you might have the limitations for specific work. So a lot of times condos, multifamily developments, we talked about the tract home exclusion, they'll put this in there to where they're not going to cover that because basically they've seen litigation, and with insurance, they're a business too at the end of the day. So they're your friend whenever they're getting checks in, but whenever they have to start sending them out in the event of a claim, that's whenever you figure out what you really have, and it's the worst time. And conditions of coverage with your subcontractor requirements. They'll use a lot of the verbiage to where, is it on the next slide, where they actually have it?
Yeah, it looks not easy. Sorry.
Put it in Braille for you. But with the subcontract agreements, if you have a surplus lines carrier, so if you have your general liability policy and you see taxes and fees, you need to run. Because what that means,
Well, no, you're gonna run, that's all we got back home.
Louisiana, they still have the parishes. But what they can do is when they're amending this with the endorsements is basically they can say, hey, if you don't have a written contract, if you don't have the $1 million worth of liability, if you don't keep contracts for 7 years, we're gonna pay $10,000 in the event of a claim. So you need to go review your policies, because if you have specific endorsements that limit what is going on between you and subcontractors, if you're not following everything, they can come back and tell you too bad, so sad. So look out for that. Like I said, if you see taxes and fees,
Read the policy.
And y'all look at what A1 says, a written agreement.
Where you at?
I think we just talked about that.
in writing.
And then also, each one of these, you notice the last, well, if you can see, the last word is and. These are not this or this. These are all of them. I mean, there are 5 different requirements. There are and this, and that, and this. And it starts off the very first 3 words, as a condition precedent to the policy providing any coverage.
They tell you to keep them for 10 years. 10 years. And this is basically where they're coming back to say, if you're not following everything that's in here, you don't have coverage.
Well, they give you 25.
Or they'll limit heavily. So prior work exclusion, basically where it gets a little bit hairy in insurance too, is you can have, in the event of a claim, it's, let's say you find a water leak 7 years down the line. You've moved your insurance carriers 3 times, they're going to start pointing fingers, because if you have a prior work exclusion, the carrier that you have right now, they're going to say, we're not going to pay. And then you get into the game of figuring out, okay, we had 1 carrier for 2 years, 2 carriers for 1 year each, and they have to start trying to work together to get it done, and everyone's going to try to exclude the work that you've done prior to that policy. Classifications, limitation, you want to make sure that you have everything outlined with what you're doing, because if you, let's say you are the GC and you're doing the work yourself, and let's say you do the roofs. A lot of carriers, you can have a roof exclusion. You want to make sure you tell your insurance agent exactly what you're doing, where you're building, what types of homes. You go into the condos, because if you're building condos you're trying to convert and your insurance carrier doesn't know, you might not have coverage. So just look out for it and make sure they know the full scope of your work, because insurance agents, we got to know what you're doing to properly cover you. and the continuous or progressive damage exclusion. Charles? He's had a lot of experience with this one.
Now it's a continuous trigger stay. I think we used to be one of 13. I believe we're up to 25 now, Taylor, and growing daily. This simply says from the day of the CO to the day of manifestation, every day was a new occurrence. They don't try and track the weather charts, almanacs, and see when it actually rained, when it didn't. So each carrier from the date of the CA to the date of manifestation is involved in the claim. And some carriers will put this on there, and that will could leave you holding 6-7 years worth of the loss out of pocket.
And the way that they kind of do that analysis, so to speak, is let's say that you build a home in 2000 and the homeowner files a suit in 2010, right? So there would be coverage from the date of that CO, substantial completion, all the way through till that filing of that claim, so it's 10 years. But if your trades carriers only have insurance for the first 6 or 7 years, the last 3 or 4 years would essentially be self-insured, right? And so there would be no coverage because they don't have the assets to cover it. So it's essentially I guess they call it time on risk analysis. And so they say, look, yeah, we've got $1 million, but you really only get 2/3 of it because that was that time period in which you were covered. The other third is not covered. That's self-insured time on risk.
And the 8-year statute of repose, like you're talking about, I mean, it's turned into an unlimited home warranty. Because with the homeowners, they're going to come after you and talk about the jury or your peers. It's just like government. Those are the people making decisions, and you look at them, the sentiment towards home builders, it's always your fault because you see all the signs everywhere, and you're just always going to be in the wrong. So you just need to keep placing as many barriers like we try to preach with contracts, insurance, to try to help you out as much as you can, because you want to have as much ammo whenever you're trying to fight these claims. And you need to work together, especially with the subs, just double checking to make sure we're all on the same page, and you need to help limit the exposures.
And on that note, though, I would say that the HBA is doing a great job of working to kind of change public sentiment against builders. I think certainly I work a lot with Adrian Kane down at the Charleston HBA, and he's done a great job of kind of spinning politically the great things that home builders do in the community, because there is this misconception that home builders just build and then take all the money and then run away off into the sunset, and that's just not the case, right? I mean, it's the same joke with lawyers, like, oh, lawyers just collect all the money. It's like, well, that's not really how it works. And so I think the HBA has done a good job and will continue to do it, but there is a need to change and work on that public sentiment, and it's nothing that you all have done individually or even as a group. It's more this sense of entitlement that we're seeing from people in general.
Taylor, you also left off, Ken builds a $500,000 house, your profit's $490, $495.
Roughly, 95% margin.
A good day.
Again, going back to the additional insured, so you have a lot of different coverage forms. The biggest thing is completed operations, because that means that you've built the house, and if you just have for ongoing, that basically means you've got coverage while they're working on it. Completed operations, whenever you're done, they actually take control of the home. You want to make sure that the completed ops is covered, so that in the event of a claim, clearly they're going to come. And there's a lot of different forms. So there's how many forms with the?
We don't have enough time.
About to say. But if you have a specific form, you want to make sure that your agent reviews it, because again, you have CG 2010, 2037, the completed ops, ongoing ops. You want to make sure that they're being reviewed just to make sure that you have the coverage that you're asking for. And the claim, you go ahead.
Just real quickly, and we're running close on time. You said, what do I need in the event of a claim? Contracts with the owners and the subcontractors, inspection reports, and I know a lot of those are done online now. Certificates of insurance with the additional insured. What are the 3 keys to real estate? Location, location, location. Mr. Stair will tell you documentation, documentation, documentation. That should be it.
Yep. What questions y'all have?
get your agent to read your policy. Typical policies, I was just looking at one contract, and it's insurance, and I break the policy out. 18 pages of coverage, 56 pages of exclusions. So,
On contracts, and this is, for me personally, we're shifting our business from custom to spec. We're buying lots, building houses and selling. I'm a real estate agent. The brokerage is not my company. I just have my license with a broker. And I'm selling the houses as well. Am I better off just using a South Carolina sale of property contract, or do I need to go? Because I see like Eastwood, you know, I just saw their thing in Charleston where they finally got their ruling. You know, they've got a 90-page contract. I sold an Eastwood house, and we went in and they presented this 97-page contract, and I'm like, I ain't got time for it. I mean,
That's interesting. So I have a case now where as you will always hear from lawyers, it depends, right? And so if you are building, if you are selling a home that has already been built, then maybe I could get behind that, maybe. If you are going to be building a home with the homeowner's input, then absolutely not. Because
any input whatsoever.
correct. So the reason is because then it doesn't give you, there's no, that's not why the South Carolina residential contract agreement does not contemplate that, like any changes. It is for a home that has already been built. And so that's why, yeah, I could see you doing it in that situation, but if there's input, then no.
Time for a contract and, so, yes, I guess,
I
you
have
know.
a family full of them.
I just say, like I said, in that situation, then, I mean, again, just purely from my personal knowledge, is just, you know, I guess at what point, if we start building a house and it's framed up, somebody comes in and says, hey, I want to pick my floor, something like that, even something as small as that should be a different type of contract.
Without a doubt, then the residential, the standard broker one, that was intended to push sales through. It was drafted by brokers to make sure that the brokers and the agents got commissions for their sales.
Yeah.
I mean, if you look at it, it's almost impossible to comply with it if to get out of it,
Yeah.
right?
Oh, yeah.
I mean, that's the whole purpose of it.
When
So,
you think about the AIA, instead of
So-
architect, build American Institute of Architects.
so
Crazy big.
yes, it's a great contract if you're actually going to comply with all the terms and conditions. I mean, there's
Well, I
a
know.
lot of requirements.
That's fine.
But I get it, and would I like that? Yes, but I'm quite busy because my builders don't always do all the things that their contracts require, and there are more requirements in an AIA contract because it's intended to be a commercial project.
Well, no, they got residential cost plus.
They do, but it's more complicated than your standard contract, and that's why I say what you need to do is have that conversation with your lawyer and say, this is how I run my business. You shouldn't mold your business to what another contract says. You should run your business how you want it and make sure that you're protected through the contract drafted for your company.
And it's got 60 pages of general conditions with it.
The AIA? Yeah, you don't want all that.
Well, actually, I've been using it for 30 years. I think it's pretty solid. I'm good with it.
So for your single family homes? Okay.
I mean, they got a thing. So some guy says he don't like this, makes you stop the job. You correct the defects. You know what the fallback on that is? Once you correct the defects, you can fire them and collect your profit and roll them down the road.
Yeah.
That's the contract they had with that wall in Mexico. That's why the contractor got his money.
Yeah, I mean, I would say that's a slightly different scenario. No, I get it, but you don't have to have.
No, it's a lot to read.
It's a lot to read, and I would say that most homeowners or prospective buyers would be less inclined because they see that as more burdensome for them. I mean, can it work? Absolutely.
It's a contract made for an architect to run the job for him.
Yep.
And it protects him. There's no escalation clause, and there's no. know, it's actually pretty good. There's no escalation clause, and then you gotta specify who's making the calls, either the owner or the bank.
Yep.
So we've modified it.
Okay.
But I see all these contracts, and I just know there's all sorts of gaps in it.
I can promise you that there.
That's where you make your living.
And this is not saying anything against anyone in this room. If I looked at every single contract in this room, I would find problems with every single one of your contracts.
If the homeowners send them over to their attorneys and they want to modify it, I said, you know, it's been around 50, 60 years.
Well,
We're just earning a fee.
Yeah, but then, so that's also what I say is, you know, builders say, oh, well, I've had this same contract for 10 years. Well, then I can assure you it needs to be updated. I mean,
Well, that's
there's,
the AIA contract.
I agree. But yeah, I mean,
But it's been litigated.
and it, I would say then it also depends on the price point of your home, right? I mean, if you're entry level, you are not going to get those homeowners to agree to an AIA contract. Right. I mean, now we're talking upper end luxury, then yes, I could see homeowners being more inclined to be able to do that. It depends on the sophistication of your clients.
Yeah, I get them now where they get a home inspector to come in before closing. I'm seeing that all the time. Which is okay. I don't mind taking care of his defects too.
That's right. Well, and we can talk off record about certain home inspectors.
I think we got one more back in the corner.
Russell Patterson?
I do.
Yeah, good question.
And you know Keith Hughes?
I know of Keith. I don't know him.
Oh, I used to litigate Eagles with him.
Is that right?
Maybe in one of your offices in Charleston.
I got, if we can do that, let me catch one more question, because we're about out of time.
Just a quick question, so we don't build houses, we remodel, so, you know, it could be as big as, interior, exterior, or just replacing windows on the outside.
Yep.
Whatever the client needs. Is there something we need to add in there? So, obviously, we're going into houses that are already pre-existing, could be a year old, 5 years old, 50 years old, doesn't matter. We're contracted to do this, but there could have been another underlying issue that no one knows about that's causing failures of windows or whatever the case may be. How do we protect ourselves? We're not building the house from the dirt up. We're just coming in and replacing the product that's there.
Bless you.
There's the other defects unknown to us or the client
Yeah.
that's causing a failure. How do we cover or protect ourselves?
So that your contract is not going to cover any pre-existing conditions, and that you need to make sure that your contract states that you are not bringing the entire house up to code. Right? I mean, some of these homes that were built in the 70s and 80s built under an entirely different code.
Correct.
So if you then have a contract that says, hey, I'm going to build your house to code, and then you're only doing a deck, right? And they have an argument that, look, you told me that, you know, when you rip off that siding, if that siding and everything else wasn't up to current code, your contract says that you bring up to code. So you need to have those qualifications of, hey, this scope is limited to X, Y, and Z and does not include A, B, and C.